Hello and welcome to another Hill and Ponton VA video blog. I'm Matthew Hill here with
Carol Ponton.
And we are doing a series on what we see the biggest mistakes that veterans make when prosecuting their VA claim. We've talked about three already. The first one was not filing a claim because someone else tells you not to. Second one was not filing all the claims that encompass what's going on with you. Again, so if you have a back disability, not filing the legs that have numbness or radiculopathy second to that. The last one we talked about was why not to file reconsideration and instead file an NOD. And today we're talking about the appeal process more and continuing the appeal. Let's say you file that NOD and you're denied. Then the regional office issues what's called a statement of the case. And Carol, what are your thoughts from that?
The statement of the case, or we call it an SOC, says that if you disagree, then you can file a VA-9 and go to the Board of Veterans Appeals in Washington. And I would say 75% of our clients don't do that.
Right.
They're afraid of that. They think they have to go to Washington. God, the Board of Appeals sounds scary to them, and they drop their claim. That is a big mistake. First of all, the rules that are used or applied at the regional office are not necessarily the rules that we think are the law. The Board of Veterans Appeals is a whole different area. They try to follow the court and the law that the court puts down.
Well, that's the first time you actually have a lawyer or an actual judge who is bound by the regulations of the VA and bound by the Congress's statutes in the court cases to actually apply those to your law. The regional office, they don't they look at their manual that tells them how to do things, but that's not necessarily the same sophistication as you'd find with the law.
And I would say that we get wonderful decisions many times from the Board of Veterans Appeals. They will give veterans benefits much farther back. They'll give them much more benefits. It's a wonderful place to be. The problem is a VA-9 is just a form. You just have to file it. And you only have 60 days. That's another problem. It's not the year that you think that you're entitled to because the NODs give you a year.
Right.
So you need to make sure you get it filed in time, and you need to make sure you know where to send it. That's another problem we have with our veterans. And on the form that you get, you'll get a statement of the case, and they will actually send you usually the form with it to file and tell you exactly where to send it. Okay? That shouldn't scare you. You don't have to go to Washington. You can say that you want a hearing in a local VA office. They can do that. You want a hearing, say, at the regional office, or you don't want a hearing at all. You just want the court to look at your case.
The board.
The board.
And something Carol and I have spoken about before is that it's important to file that. And, you know, if you don't want a hearing, frankly, that'll be a faster avenue. But you need to think about why your case was denied. And if you think it was denied just because the decision maker wasn't paying attention, that's one thing. But if they're telling you there's missing piece of evidence, meaning, you know, you had the back injury in service, you got a back diagnosis now, but there's no connection, there's no nexus where a doctor said, what you have now is related to then, you're not going to win. So you need to think about what evidence you're going to put in the file to help win. But what I'd say is that the farther your case goes up the appeal chain, the more sophisticated of an adjudicator, of a decision maker you are going to encounter. So, you know, we always file for the DRO process in the regional office. And
so when you're denied initially, you have a choice of the traditional or the decision review officer.
At the regional office.
And you want to take the decision review officer.
And then if you're denied, as we're talking about here, by that person or someone else in the RO, going to the BVA entitles you a review by a judge. And that's the first review by a judge you're going to get. And they, as we were saying, they know the law, they know the case law, the regulations, and they're going to follow it. But you still have to give them the evidence they need.
Right. You have to figure out, why are they denying me? Are they denying me because there's no problem with my back? Or are they denying me because they say what's wrong with my back is not related to the service? And then you need to go get that evidence.
Right. Well, that was our big mistake number 4, which is not appealing to the BVA. Please stay tuned to this channel for the other mistakes and all our other video blogs. Thanks so much.